Welcome to my podcast, Being Honest with Sriram Rangan. Today, we will talk about the N12 application, the truth, the risk, and the consequences. Today, I want to talk about the N12 application, one of the most misunderstood and misused notice under the Ontario Residential Tenancy Act. On paper, an N12 sounds very simple. In reality, it is one of the highest risk notices a landlord can serve. Let's break this down properly. What is an N12? An N12 notice is used when a landlord claims that the rental unit is required for personal use that includes the landlord's spouse, a child or a parent of the landlord, or a caregiver for one of those individuals. The key requirement is good faith intention to genuinely move in and occupy the unit for at least 1 full year. This is not optional, this is statutory. A critical point many landlords miss. You do not need to serve a formal N12 document for the law to apply. In law, emails, text messages, WhatsApp messages, or written statements saying, I want to move back into my house can be treated as an N12. At the landlord and tenant board, substance matter more than form. If the message communicates intent to occupy, the board will often treat it as an N12 application. It has seen landlords lose. I have seen landlords lose cases because of casual texts they thought were harmless. This is a serious trap. Pros of an N12 from a landlord's perspective. Let us be fair. There are legitimate uses. Allows a landlord to recover possession of a genuine family need. No requirement to prove rent arrears or tenant misconduct. Fixed termination date, end of term. Faster than many fault-based applications. When used properly and honestly, N12 is lawful and necessary. The cons and risk. This is where people get burnt. This is where most landlords underestimate the danger. The landlord bears the burden of good faith. Intent is judged both before and after eviction. The LTB closely examines conduct, not just testimony. Any inconsistency can destroy credibility. The penalty exposure is enormous. And here's the most important part. What happens if the landlord does not move in? This is where things turn ugly. If the landlord does not move in, or moves in briefly and leaves, or rents the unit to someone else, or sells the property shortly after eviction, the tenant can file a T5 bad faith application. The board can order up to $50,000 in compensation, return the unit, moving expenses of the tenant, increase rent differences, administrative penalty, fines payable to the tenant. And yes, this includes cases where the landlord intended to move in but later changed their mind. The board often asks, if you needed the unit so badly, why didn't you occupy it? Good faith is not just intention, it is follow through. One of the biggest myths many landlords think, if I change my mind, that is allowed. That is simply not true. The law expects serious intention at the time of notice, reasonable step forward towards occupancy, actual occupation for a minimum 1 year period. Anything less can trigger bad faith finding. Practical advice, my opinion. If you are a landlord and you are not 100% certain you will move in and stay, do not serve the N12. Do not send texts or emails claiming personal use. Do not rely on I will figure it out later. N12 is not a strategy, it is a commitment with teeth. For tenant, save the messages. Screenshots count. Casual landlord statements can become powerful evidence. In my closing message to you all, the N12 is one of the most powerful and yet dangerous tool under the Residential Tenancy Act. Used correctly, it works. Used casually, it can financially destroy a landlord. And remember, words matter. Text counts. Intent without action is not protection. That is the hard reality of N12 in Ontario today. Thank you for listening to my podcast, Being Honest with Sriram Rangan. I look forward to my other podcasts and my communication with you. Have a blessed day.